Hi, I'm Cliff Ennico, legal and tax editor of ityourbiz.com with some thoughts on starting a business. So, you've been downsized from a corporate employer, you've been out of work for a couple of months, you're looking for work, but you also have an idea for a great startup business, and it's an idea that came to you while you were working for your former employer. Let's say it's a web-based business, you have an idea for a new kind of website to do something online that hasn't been done online before. Can you start this business? Or do you have to worry that your former employer might come down and make you stop it at some point? What are the things you have to think about when you're starting a business and the idea came to you while you were working for somebody else? Obviously, with people being laid off left and right by large corporations these days, this is a very, very significant concern for a lot of people. A lot of people were working on projects when they were in corporate America that caused them to have ideas, and now they want to exploit these ideas for commercial gain now that they're on their own. Can they do it? Well, the short answer, believe it or not, is yes, if you didn't sign anything with your former employer. If you didn't sign anything with your employer and it wasn't something that they would view as a trade secret, it wasn't based on some secret formula or something that was unique and proprietary to them. You didn't make a CD of all their proprietary software and are now looking to sell it on the open market. As long as you're not doing something as blatant as that, as long as it's an idea that occurred to you while you were there and you are not stealing their trade secrets, you should be able to exploit that idea commercially in your own business. But that's not usually the case, of course. Usually the case is that corporations are very much aware that people want to do this, so that when you leave, they make you sign these awful termination agreements that contain all kinds of clauses saying that anything you ever thought of or that ever occurred to you while you were an employee of the company belongs to them. We call that an assignment of rights clause. And if that assignment of rights clause is not properly drafted, it could bar you from starting a business of your own. Always make sure whenever you sign a termination agreement that you have an attorney look it over before you sign, and make sure you tell the attorney specifically that you are planning to start a business, you have an idea, it doesn't really relate to the business of your former employer, but it's something you did think of while you were working there. You want to know that you have the right to do it. Because you're going to have to insert specific language in that termination agreement to make sure that you can do it. And here's what that language should look like. Number one, the assignment of rights clause should only be limited to things where you either used company property or you actually worked on the project during company time. If you were working on a project during company time, you were being paid for it, the employer does own it. It's something called the work made for hire doctrine, and you should not be exploiting that for commercial gain. If it was a project that you worked on company time, it belongs to your former employer. Forget about it, think about something else. The second thing is the assignment of rights clause should only apply to things where you actually used company resources. So if you were using a company chemistry lab and you came up in your spare time with some secret formula for some wonderful new soda or something like that, but you were doing it using the company's lab facilities, that's a no-no. That belongs to the employer, and you simply cannot exploit that. If they catch you doing that, there probably will be a paper trail that will lead to you, and you will get into some big trouble. But anything else, if it was just an idea that was never reduced to practice, and especially if it does not relate to the former employer's business, if it's not something that they would look at as an opportunity for themselves, then you should have the right to do it, and the assignment of rights clause should be drafted in such a way that you can exploit that idea, become the next Mark Zuckerberg, and never have to look back. But make sure you have the help of a good attorney. This clause can be very, very tricky to draft, and it's not the kind of thing you should be doing yourself. Get the advice of a seasoned employment lawyer before you take those first baby steps to exploit this new technology that you've come up with. I'm Cliff Ennico for ityourbiz.com.